Introduce our first speaker, Professor Manik Chakrabarty.
Thank you, Professor Bagchi. Good evening, all. It is an immense pleasure for me to introduce Professor Manik Chakrabarty. He is former professor and head Department of Law, University of Burdwan. He is quite experienced in handling various academic administrative duties. He was director, UGC Academic Staff College, Burdwan University. He was controller of examinations in the same university. He was also attached with Amity University, Kolkata as an advisor of Amity Law School. Professor Chakrabarty has a long illustrious teaching experience of 35 years. His contribution in the academia is commendable. He has published 3 books and 40 research articles in various research journals out of his own capacity. Professor Chakrabarty has produced 17 PhD scholars. Apart from this, he is a member of many PG Board of Studies in various educational institutions like Guwahati University, Raigat University, Vidyasagar University, Gaurbanga University, and Patna University. He is an expert member of Human Rights Study appointed by the UGC. Presently, Professor Manik Chakrabarty is teaching as visiting faculty in PG Human Rights in the Department of Anthropology, University of Calcutta. So this is a very brief introduction for Professor Chakrabarty. I request him to enlighten us with his deliberation on the legal aspect of the farm law in India. Over to you, Professor Chakrabarty. Thank you.
Good evening, ladies and gentlemen. I welcome you all in this webinar. Today it is the 159th birth anniversary of Swami Vivekananda. So first of all, I pay my regards to Swami Vivekananda before starting my discussion. And also my heartfelt thanks and congratulations to the Kolkata Study Circle for organizing such an important webinar on a debated topic, that is farm laws, existing farm laws. And so I feel it is an honor and privilege to speak in this occasion before the August gathering. Ladies and gentlemen, as you have heard and you have seen in the media, thousands of farmers are at the Delhi border with over 40 unions, farmers' unions, threatening to intensify their month-long agitation across the country if the government does not repeal the 3 farm laws passed by the parliament in the last monsoon session. As you have heard from Professor Subrata Bagchi that I've been assigned to discuss the laws only. This is my part. So as the whole debate is, now concerned with these 3 laws passed by the parliament, so I will try to discuss the provisions of these laws and also their background, how these laws have come and introduced by the government. Several petitions, as you have heard, are already filed before the Supreme Court of India. While some of the pleas sought the removal of the protesting farmers camping around Delhi borders, surrounding Delhi, and others challenging the validity of these laws. Today, as we have seen that already 8 rounds of discussion talks between the protesting farmers and the government, held, and it has been failed miserably to reach any consensus. And finally, the Supreme Court of India, has come to the scene, to mediate the whole thing. And today, in the media, we have seen that a bench comprising 3 honorable judges, headed by Chief Justice of India, Justice S.A. Bobde, they have suspended this implementation of these 3 laws, and at the same time set up a committee to discuss the whole issue with the farmers and to settle down the impasse. Now, a set of questions have been filed with the Supreme Court, challenging the competence of the union government to legislate on matters which are fundamentally state subjects, as we have found in the Indian Constitution. Now, can the union government violate the constitutional mandate and also the objects of the framers of the Constitution while they are making a law? This is a big question before the Supreme Court of India now. Now, here I must say that as already you have heard that 3 laws have been passed by the Indian government in the last monsoon session. These are the Farmers Produce Trade and Commerce Promotion and Facilitation Act, the Farmers Empowerment and Protection Agreement of Price Assurance and Farm Services Act, and the Essential Commodities Amendment Act 2020. Now, of course, these laws came in the month of June as a three ordinances before being approved by the Parliament during the monsoon session by a voice vote. The government has presented these laws as reforms on agricultural system. Now, it is important to note here that government has been arguing that these three laws open up new opportunities for the farmers so that they can earn more from their farm produces. According to the government, key provisions of the new farm laws are intended to help small and marginal farmers who constitute 86% of the total farmers in India who don't have means to either bargain for their produce to get a better price or invest in technology to improve the productivity of the farms. Now, the government also has said that the new laws will help to strengthen basic farm sector infrastructure through greater private investments. Now, here I want to remind you that till last year, the sale of agricultural produce could occur only at the market year, that is mandis of the agricultural product market committees, APMCs. And these APMCs are regulated mainly by states through them, through their adoption of Agricultural Produce Marketing Regulation Act. During 1960s and 70s, most of the states in India, they have enacted and enforced this Agricultural Produce Markets Regulation Act. All primary wholesale assembling markets were brought under the ambit of these acts. Well laid out market years and sub-years were constituted, and for each market area, an agricultural produce market committee was constituted to frame the rules and enforce them. Thus, the organized agricultural marketing came into existence through regulating markets. By establishing this APMC, the state government wanted to safeguard the farmers from exploitation by large retailers. Now, as we know, these farm laws have been rejected by the farmers' union as they believe that the creation of the private mandis along with the APMCs will drive agricultural business towards private mandis, ending government markets, intermediary systems, and also APMCs. As a result, big corporate houses will overtake markets, thereby procuring farm at incidental rates. Thus, they are demanding the repeal of these laws, and instead they're demanding for a comprehensive act on minimum support price all over India and for all crops. Now, here I must say that in India, the history of agricultural produce market regulation, that program, dates back to colonial era, where raw cotton was first produced to attract the attention of the British administration. The rulers wanted to make available the supplies of pure cotton to the textile mills of Manchester in UK at a reasonable prices. As a result, in the year 1886, the first regulated market under Hyderabad Residency Order was established, and in 1987, the first law in India, the Bearer Cotton and Grain Market Act, was passed by the British government. The Act empowered the British resident to declare any place in the assigned district a market for sale and purchase of agricultural produce and constitute a committee to supervise the regulated markets. The Act soon became the model for the enactment in other parts of the country as well. Now, here I must mention, in 1928, the Royal Commission on Agriculture recommended setting up of regulated markets to improve the trade practices and to establish market years in the country. In pursuance to that, the government of India prepared a model bill in 1938 and circulated to all the state governments, but not much headway was made till the independence. Now, prior to independence, here I must mention the major concern of the government policy related to agricultural marketing was to keep the prices of food for the consumers and agro materials for the industry to check. However, after independence, the whole scenario has been changed. Now, after independence, the need to protect the interests of the farmers and to provide them incentive prices to augment the production of agricultural commodities was also felt. Recognizing the defects like losses to the farmers in terms of undue low prices, higher cost of marketing, considerable physical losses of the produce in the agricultural marketing system, which the farmers had to face, the government, with a view to establishing a mechanism to monitor the market conduct, many states enacted the Agricultural Produce Markets Regulation Acts. And of course, in 1961, the Punjab government, they enacted the Punjab Agricultural Produce Markets Act 1961, which was followed by the Haryana government in 1961. And so far the West Bengal is concerned, as we have seen, the West Bengal Agricultural Produce Marketing Regulation Act was passed in 1972. And the West Bengal Agricultural Produce Marketing Regulation Rules was passed in the year 1982. Though, of course, the act was subsequently amended in 2014, 2017, and the rule was also amended in the last year, that is 2020. Now, on 19 December 2000, an expert committee was set up by the Ministry of Agriculture under the chairmanship of Sankar Guru for the purpose of strengthening and developing the agricultural marketing in India. The Guru Committee made several recommendations, one of which included remodeling the APMC Act, already existing in India. In July 2001, again a task force on employment opportunities was set up under the chairmanship of Mantik Singh Aurelia. The task force made several observations, of which one was to repeal the Essential Commodities Act 1955, which is very important to note here, of course. Accordingly, in the month of September 2003, the Union government drafted a Model APMC Act 2003 in order to reform the APMC across the country. And under this Model Act, provisions were made for direct sale of farm produce to contract farming sponsored from farmers' field without the necessity of routing it through notified markets. All the states were directed by the central government to amend their existing APMC Act on the line of this Model APMC Act made by the government, Union government. Now, here I must mention the second report of the National Commission of Farmers, chaired by M.S. Swaminathan, also clearly proposed that the APMC Act in different states and union territories needs to be amended immediately on the lines of the draft of the amended APMC Act circulated by the Government of India, so that private sectors may invest for the development of agricultural marketing. Now, so but here, according to this commission, the role of the government should be only that of facilitator. Now, here I must say, the Model APMC Act, which was drafted by the Government of India, it provides for direct sale of farm produce to contract farming sponsors. And at the same time, it provides for setting up special markets for perishable goods and permits private persons, farmers, and consumers to establish new markets for agricultural produce in any area It replaces licensing with registration of market functionaries, which would allow them to operate in one or more different market areas. It provides for the establishment of consumers and farmers markets to facilitate direct sale of agricultural produce to consumers. Thus, if we go through this Model Act, then we'll find that the Model APMC Act provides freedom to the farmers to sell their produce directly to the contract sponsors or in the market set up by the private individuals, consumers, or producers. Here, I must mention again that in the year 2019, the Ministry of Agriculture set up a standing committee under the chairmanship of Hukum Dev Narayan to review the loopholes of the agricultural marketing and also the role of weekly Gramin Haats. After going through this report of this committee, standing committee, it is found that the committee straightway observed very clearly that scarcity of marketing platforms for agricultural produce and management and corruption in APMC markets have created a situation where farmers are being deprived of fruits of their hard-earned labor, leading to the low price realization for their farm produce. So accordingly, the present India government last year in the month of September 2020, enacted these three farm laws and amended also the Essential Commodities Act 1955. Now, let me discuss these three existing laws, farm laws, what they are. Then I will come to the legal questions, those who have found before us. First of all, I must mention here the Farmers Empowerment and Protection Agreement on Price Assurance and Farm Services Act 2020. In the very preamble to this act, it has been clearly mentioned, this is an act to provide for a national framework on farming agreements that protects and empowers farmers to engage with agribusiness farm processors, wholesalers, exporters, or large retailers for farm services and sale of future farming produce at a mutually agreed remunerative price framework in a fair and transparent manner, and for matters connected therewith or incidental thereto. Now, if we go to the provision of this act, then here I have seen that farming agreement, that is very important to note down here, which has been mentioned under section 2, clause G. Farming agreement under this law means a written agreement entered into between a farmer and a sponsor, or a farmer, a sponsor, and a third party prior to the production or rearing of any farming produce of a predetermined quality, in which the sponsor agrees to purchase such farming produce from the farmer and to provide farm services. So, for this purpose, the term farm agreement may include trade and commerce agreement, where the ownership of commodity remains with the farmer during production and he gets the price of produce on his delivery as per the agreed terms with the sponsor. Production agreement, where the sponsor agrees to provide farm services either fully or partially and to bear the risk of output, but agrees by such farmer, and such are the agreements or a combination of agreements specified above. Now, farm produce, the term farm produce, rice and wheat, it mentioned here in this act, actually, it has been defined under section 2, subsection H, farm produce, which includes foodstuffs, including edible oilseeds and oils, all kinds of cereals like wheat, rice, or other coarse grains, pulses, vegetables, fruits, nuts, and spices, sugarcane, and products of poultry, piggery, goatery, fishery, and dairy intended for human consumption in its natural or processed form. Cattle fodder, including oil cakes and other concentrates, raw cotton, whether gained or ungained, and cotton seeds and raw jute. So these are now included within the purview of the term farming produce. Now, next, let us come to Section 3 of this Act. Section 3 of this Act clearly mentions a farmer may enter into a written farming agreement in respect of any farming produce, and such agreement may provide for the terms and conditions for supply of such produce, including the time of supply, quality, grade, standards, price, and such other matters, and the terms related to supply of farm services, provided that the responsibility for compliance of any legal requirement for providing such farm services shall be with the sponsor or the farm service provider, as the case may be. And no farming agreement shall be entered into by a farmer under this section in derogation of any rights of a sharecropper, that is, rights over the land. Now, the minimum period of farming agreement shall be for one crop season or one production cycle of livestock, as the case may be, and the maximum period shall be 5 years. For the purpose of facilitating farmers to enter into written farming agreements, the central government may issue necessary guidelines along with the model farming agreements in such a manner as it deems fit. Now, under Section 5 of this Act, it is mentioned the price to be paid for the purchase of a farming produce may be determined and mentioned in the farming agreement itself, and in case such price is subject to variation, then such agreement shall explicitly provide a guaranteed price to be paid for such produce. This is very important, Section 5, a guaranteed price to be paid for such produce. Now, the sponsor may, before accepting the delivery of any farm produce, they have the right to inspect the quality or any other feature of such produce as specified in the farming agreement. Otherwise, he shall be deemed to have inspected the produce and shall have no right to retract from acceptance of such produce at a time of the delivery of thereafter. Now, the state government may prescribe the mode and manner in which the payment shall be made to the farmer under subsection 3 of this section 2. Now, section 7 of this Act clearly mentioned where a farming agreement has been entered into in respect of any farming produce under this Act, such produce shall be exempt from the application of any state act. This is very important to note here. Again, I'm repeating, where a farming agreement has been entered into in respect of any farming produce under this Act, such produce shall be exempted from the application of any state act by whatever name called, established for the purpose of regulation of sale and purchase of such farming produce. So, in section 8 also it is mentioned, no farming agreement shall be entered into for the purpose of any transfer, including sale, lease, and mortgage of the land or premises of the farmer. And finally, I must say that under section 12 it is mentioned, a state government may notify a registration authority to provide for electronic regular registry for that state that provides facilitative framework for registration of farming agreements. And under section 13, the disbursement mechanism have been mentioned, and it has been mentioned that if there is any dispute between the farmers and the sponsor, then in that case, there will be a conciliation board which will go into the matter and solve the disputes in an amicable way. Now, let us come to the next act. There is the Farmers Produce Trade and Commerce Promotion and Facilitation Act 2020. Here it is mentioned that this is an act to provide for the creation of ecosystem where the farmers and traders enjoy the freedom of choice relating to sale and purchase of farmers' produce, which facilitates remunerative prices through competitive alternative trading channels to promote efficient, transparent, and barrier-free intrastate trade and commerce of farmers' produce outside the physical premises of markets or deemed markets notified under various state APMC, as I have mentioned, to provide a facilitative framework for electronic trading and for matters connected therewith and inserted there too. Now, under this act, very interesting here, what I have seen, that here the term person includes an individual, a partnership firm, a company, a limited liability partnership, a cooperative society, a society, or any association or body of person duly incorporated or recognized as a group under any ongoing programs of the central government or the state government. And here one interesting point I have seen mentioned by the central government, which is very unique because it was not mentioned in the earlier act, that is trade area. Trade area that has been defined under section 2, clause M, where it has been mentioned that trade area means any area or location, place of production, collection, and aggregation, including farm gates, factory premises, warehouses, silos, cold storages, or any other structure or places from where trade of farmers' produce may be undertaken in the territory of India, but doesn't include the premises, enclosures, and structures constituting physical boundaries of principal market yards, sub-market yards, and market yards, that is mandis, managed and run by market committees formed under the State APMC Act in force in India. So this is very interesting here. I must mention that as if it has been shown that this is an additional opportunities given to the farmer, because keeping APMC, mandis and all, now the government has created a new trade area and defined it almost same like market, mandi area, but at the same time, here it is mentioned that, of course, but doesn't include the premises, enclosures, and structures constituting, physical boundaries or mandis and all these things, formed under the State APMC Act in force in India. So this is also a point of discussion, because when the farmers are very much now concerned with these mandis and new mandis or new trade areas to be opened up, then what will be the condition of the existing mandis under the APMC Act? There is a big question. Of course, we have seen that the central government many times, they assured the farmers' unions that no, these existing mandis will be there, and the government, and that will work as usual, like previous years. But besides this trade area, also new trade area, will be operating as additional opportunities to the farmers. So this is a big question now. Why the central government is providing these additional opportunities while the keeping existing also mandis also in presence. Now, again, section 3 of this act mentioned, subject to the provisions of this act, any farmer or trader or electronic trading and transaction platform shall have the freedom to carry on the interstate or intrastate trade and commerce in farmers' produce in a trade area. Now, any trader may engage in the interstate trade or intrastate trade within the boundaries of the trade of scheduled farmers' produce with a farmer or another trade in a trade area, provided that no trader except the farm producer organization or agricultural cooperative society shall trade in any scheduled farm produce unless such a trader has a permanent account number allotted under the Income Tax Act 1961 or such other document as may be notified by the central government. So this is another very important point to note down, that they must have the permanent account number as allotted under the Income Tax Act 1961. Now, the central government may, of course, if it is of the opinion that it is necessary and expedient in the public interest to do so, prescribe a system for electronic registration for a trader. So the power has been kept at the hand of the central government in the public interest here, and the modalities of trade transaction and mode of payment of the scheduled farmers' produce that in the trade area, that may be also trained by the central government under section 3, section 4, subsection 2 of this act. Now I am coming to another important section of this act, section 6 of this act. This is very important. no market fee or cess or levy by whatever name called under any state APMC Act or any other state law shall be levied on any farmer or trader or electronic trading and transaction platform for trade and commerce in scheduled farmers produce in a trade area. So this is very interesting here. So presently what the state government is doing, earning revenue, now that has been totally stopped because it is clearly mentioned that no market fee or cess or levy by whatever name called under any state APMC Act, the existing state APMC Act or any other state law shall be levied or on any farmer or trader or electronic trading and transaction platform for trade and commerce in Schedule A, scheduled farmers produce in trade area. Mind it, please mind, here Mundi or all these things have not mentioned. Trade area. As I told that this is a unique term, coined by the central government when framed the law. And this particular section 6 of this act is very important because the state government is going to lose the whole revenue under this section 6 of this act. Now, again, section 7 of this act mentioned that the central government may, through any central government organization, develop a price information and market intelligence system for farmers' produce and a framework for dissemination of information trading thereto. And so far the dispute resolution system is concerned, it has been mentioned under section 8. If there is any kind of dispute with the producer, the farmers and the private sponsors, then in that case, arising out of a transaction between the farmer and a trader under section 4, then the parties may seek a mutually acceptable solution through conciliation. So the process of conciliation by filing an application before the subdivisional magistrate, who shall refer such dispute to a conciliation board to be appointed by him for facilitating the binding settlement of the dispute. So now here, so this is the second law where I have gone through. Now let us come to another most important law here, that is the Essential Commodities Act 1955. Now, see, please remember, in 1955, the government of India, this parliament has enacted this Essential Commodities Act. And under this act, the government of India regulates the production, supply, and distribution of a whole host of commodities it declares essential in order to make them available to consumers at fair prices. Under this act, the government also can fix the MRP, minimum rate, of any packaged product that it declares as an essential commodity. The center can also add commodities in this list because there is a schedule in this list where all the essential commodities, name of the commodities have been mentioned in this act, and the central government can also add commodities in this list when the need arises and can take them off the list, outside the list, once the situation improves. Now, if a certain commodity is in short supply and its price is spiking, then the government can notify such stock holding limits on it and for a specified period. So for the powers of the state government under this act, I must mention that under this act, the respective state governments can choose not to impose any restrictions as notified by the central government. However, if the restrictions are imposed, traders have to immediately sell any stock held beyond the mandated quantity into the market. And this is done to improve supplies and brings down the prices. Now, I must mention here that so far the act is concerned, if you see the section 2A, a new section has been inserted in this act by amendment, section 2A, in the year 2006, by the amendment of this act by the parliament, where it has been mentioned, for the purposes of this act, essential commodity means a commodity specified in the schedule of this act, as I have just mentioned. Subject to the provisions of subsection 4, the central government may, if it is satisfied that it is necessary so to do, in the public interest. Please mind here, in the public interest and for reasons to be specified in the notification published in the official gazette, amend the schedule, as I have mentioned that there is a schedule provided under this act, can amend the schedule so as to, in public interest, so as to add a commodity to the said schedule or remove any commodity from the said schedule, whatever we have seen now under the amendment, present amendment made by the parliament in last year. It is very important, section 2A here, because the central government has given the power under section 2A here, that it can add a commodity to the said schedule in the public interest, or it can also remove any commodity from the said schedule in consultation with the state governments, of course. Now, again, under this section 2A in subsection 4, it has been mentioned, the central government may exercise its power under subsection 2 in respect of the commodity to which parliament has power to make laws by virtue of entry 30 in list 3, third in list 3rd in the 7th schedule of the Constitution. And every notification issued under subsection 2 shall be laid as soon as maybe after it is issued before both the House of Parliament, what the central government has done in the last monsoon session of the Parliament. Now, of course, here I must mention that under section 3, it is clearly mentioned the central government is, if the central government is of the opinion that it is necessary or expedient so to do for maintaining or increasing supplies of any essential commodity or for securing their equitable distribution and availability at fair prices, then it may by order provide for regulating or prohibiting the production, supply and distribution thereof and trade and commerce therein. Now, let us see what are the amendments made by the central government, the parliament in the last monsoon session of this Essential Commodities Act. See, in the last monsoon session, this Act, Essential Commodities Act, has been amended. So this is known as Essential Commodities Amendment Act 2020. Here, in section 3 of the Essential Commodities Act 1955, after subsection 1, what just now I have read, then 1A, a new subsection has been added. A new subsection 1A has been added under section 2, under section 3 of the Essential Commodities Act, under section 3. Now, what is mentioned here? Under subsection 1A, it is mentioned that notwithstanding anything contained in subsection 1, the supply of such foodstuffs, including cereals, pulses, potato, onions, edible oilseeds, and oils, as the central government may, by notification in the official gazette, specify, may be regulated only under extraordinary circumstances, which may include war, famine, extraordinary price rise, and natural calamity of grave nature. Now, then again mentioned here, any action or imposing stock limit, shall be based on price rise, and an order for regulating stock limit of any agricultural produce may be issued under this act only if there is 100% increase in the retail price of horticultural produce or 50% increase in the retail price of non-perishable agricultural foodstuffs. This is also very important, this one. Provided that such order for regulating stock limit shall not apply to a processor or value chain participant of any agricultural produce if the stock limit of such person doesn't exceed the overall ceiling of installed capacity of processing or the. But very important to mention here, again it is mentioned here, provided further that nothing contained in this subsection shall apply to any order relating to public distribution system. Please note down this amendment. Here it is clearly mentioned under this amendment that nothing contained in this subsection 1A, which has been inserted by this amendment by the Parliament in last monsoon session, nothing contained in the subsection 1A shall apply to any order relating to the public distribution system, PDS, as Professor Subrata Babu has mentioned regarding the PDS system, existing PDS system. So nothing contained in this subsection 1A shall apply to any order relating to PDS, public distribution system, or the targeted public distribution system made by the government under this act or under any other law for the timing in force. So this is very, very important here that public distribution, so far the public distribution system is concerned, the government, the union government did not try to interfere, of course. Now, the question here, what have been challenged before the Supreme Court, so what the competence of the union government to legislate on state matters. Here, see, if we talk about our Indian Constitution, then we will see that the whole legislative powers are distributed through the 7th schedule to the Constitution, which contains, of course, a union list, a state list, and a concurrent list. Now, agriculture with all associated subsidiary enterprises, including education and research, livestock, fisheries, irrigation, etc., is a state subject. Please note down, this is a state subject. Markets and fairs are also a state subject under entry number 28 of the state list. Even a trade and commerce within a state is also a state subject under entry 27 of the state list. Now, of course, now, after an amendment to the Indian Constitution, that is third amendment to the Indian Constitution in 1954, now all these things have been now kept under the union government subject to entry 33 of the concurrent list. That, however, all these things are subjected to the entry 33 of the concurrent list. Now let us see what is entry 33 mentioned in the concurrent list. See, actually I must say that it is this entry 33 of the concurrent list which has been put to use by the central government to bring this farm acts. Entry 33 in its current forms, of course, it mentioned the trade and commerce in and the production, supply, and distribution of, number one, the products of any industry where the control of such industry by the union is declared by the parliament by law to be expedient in the public interest, and imported goods of the same kind, such products. Number two, foodstuffs, including edible oil, seeds, and oils. Number three, cattle fodder, including oil cakes and other concentrates. Number four, raw cotton, whether ginned or unginned, and cotton seeds and raw jutes. Now, interestingly, as I have mentioned, that industries are also a state subject under entry 4, but with a rider that Parliament by law may declare any industry to be under the control of union government if it is necessary for the purpose of the prosecution of war as mentioned under entry 7 of the union list, or where Parliament feels that it is expedient in public interest under entry 52 of the union list. Now, as I have mentioned, that in 1954, the Parliament has made the amendment to the Indian Constitution, which is known as the Third Constitutional Amendment Act, 1954. Now, interestingly, the framers of the Constitution put no such rider with regard to agriculture or markets. The framers of the Constitution, I must mention here, put no such rider with regard to agriculture or markets, which shows that these are essentially the state subjects. It is due to the peculiar circumstances that entry 33 in the concurrent list came to be amended by way of third amendment to the Constitution in 1954. And the sub-entries B to E were introduced. B to E were introduced under this third amendment. B mentions foodstuffs, including edible oil, seeds and oils. C mentions cattle fodder, including oil cakes and other concentrates. And D, raw cotton, and E, raw jute. So these have been incorporated by third amendment of the Constitution in 1954. Now, there is a history and background to the third amendment by which the scope of entry 33 was enlarged. I want to discuss this before the August gathering because this is very important when this has been challenged by petitioners before the Supreme Court about the constitutionality of these enactments on the basis of this entry 33. Because there is a background to this. See, trade and commerce within the state and production, supply, and distribution of goods were the matters enumerated in the provincial list as per the Government of India Act 1935. Now, due to the Second World War, emergency was declared and the central legislature acquired the power to legislate on these matters which were in the state or oblique provincial list. It was previously on the state list. Now, after the end of the war, it was lifted on 1st April 1946. However, the power to legislate on these matters was sought to be retained by the Dominion government due to prevailing circumstances and scarcity of essential items. For this purpose, then, the British Parliament enacted the Indian Council Government and Legislature Act 1946, permitting the Dominion government to legislate on certain state subjects. And in addition to it, the Dominion government also enacted the Essential Supplies Temporary Powers Act 1946, which has been replaced by the now this particular law, that is the Essential Commodities Act 1955. Now, these two enactments were to operate for a period of 1 year, but the lives of these enactments were extended from time to time. The Constitution of India came into effect on 26 January 1950, and the Constituent Assembly, with a view to carry on with this arrangement, whereby the Union government could legislate on certain matters within the state list, inserted Article 369 in the Constitution as a temporary provision for a period of 5 years. Now, the lives of the Article 369 and the Essential Supplies Temporary Powers Act 1946 were to expire on 26 January 1955. However, the situation of food articles and other essential supplies in the country was still precarious, and the menace of hoarding and black marketing still existed. So, with a view to continue with the same arrangement, 4 sub-entries were introduced, as I have mentioned, in the entry 33 by way of a third amendment to the Indian Constitution, and alongside the Essential Commodities Act 1955 also was enacted by the Parliament. Now, so what the entry 33 is concerned, see, entry 33 of the concurrent list enabled Parliament to legislate in respect of industries declared to be under Union control. In addition, Parliament was empowered by Article 369 for a period of 5 years to legislate in respect of certain specified essential commodities. Now, it was not considered advisable that after Article 369 lapsed to control the production, supply, and distribution of some of these essential commodities. It is not advisable. So the bill seeks to amplify entry 33 of the concurrent list accordingly. Now, thus the amended entry 33 and the Essential Commodities Act principally equipped the Union government to tackle the scarcity of essential articles, hoarding, black marketers, and additional price rise, among other things, in the country, and were never meant to be used in a general situation. The Parliament at the time of carrying out the third amendment could well have created a separate entry in the concurrent list, but it was not done. Rather, foodstuffs and other items were grouped with the existing item in entry 33, which also indicates that the intention of the Union legislature was to resort to these entries only in exceptional circumstances. Now, the interpretation which the present Union government given to entry 33, this is very interesting, of course. the Union government has tried to it as a standalone provision, and it conveniently ignored the context, object, and historical background. And also, I must say, the intention of the framers of the Constitution when it was inserted, and also the framers of the legislators, the laws, when it is inserted in the entry 33 of the Indian Constitution. Now, with the Farmers Produce Trade and Commerce Promotion and Facilitation Act, the center seeks to control of the entire intrastate sale and purchase of all the agricultural produce, and has stampled upon the entire space, which is otherwise a domain of the state governments. This is very important. Now, here lies of course, the actual interpretation of the entry 33, because it is clearly mentioned that the intention of the Union legislature when it was inserted, it was to resort to these entries only in case of emergency circumstances or exceptional circumstances. But now the question remains whether in 2020 there was any exceptional circumstances when the government had to take resort to these provision. Now, secondly, Section 6 of this Act, the Farmer Produce Trade and Commerce Promotion and Facilitation Act, Section 6.
Professor Chakrabarty,
Yeah.
I have a humble request. Could you please finish it within the next 5 minutes?
Just 2 to 3 minutes, I'm finishing.
Thank you.
So Section 6 of the Act, of this Act, as I have mentioned, the Farmers Produce Trade and Commerce Promotion and Facilitation Act, Section 6, it lays down that the state will not charge any market fee, cess, or levy on the trading of farm produce. This is again a clear encroachment on the domain of the states. So, Entry 33 deals only with the trade and commerce of foodstuffs and other items, and permits no such interference that the central government can legislate on the subject of market fee, cess, or levy, much less prohibit the state from levying the same. This is very important to know. And as I have mentioned, no term such as trade area already we can find in the Constitution. The power to legislate on markets and fairs is only with the state governments under Entry 28 of the Constitution. So the Union government cannot whittle down the legislative sphere of the states, nor can entry in the 7th schedule be overridden or rendered otherwise by merely enjoying different terminologies. Now, it is very important to note that the whole now case is pending before the Supreme Court. And of course, the Supreme Court, in the light of the known principles of interpretation, can apply the principle of judicial review and take a decision. But however, the Supreme Court has taken the process of amicable solution, as you have seen today, by setting up a committee. So now we have to watch and wait for the whole thing, what comes next. So with these words, thank you very much. I'm grateful to the organizer for giving me this opportunity to discuss with the August gathering my ideas on these 3 laws mentioned passed by the Parliament. So with these words, thank you again. Thank you very much. Namaskar.
Thanks a lot, sir, for enlightening us about the legal aspect of the farm law in a very lucid manner. In your deliberation, it is elaborately discussed about the history of the APMC Act. It is clear that how the farm law has been evolved in India since from the colonial era. It is also understood that after the independence of India, it was tried to protect the interest of the farmers by the government of India. You have also talked about the different loopholes of the Act. From your deliberation, we have come to know about the constitutional framework of the laws. It is also understood from the speech that how the existing 3 laws has been enacted by the Parliament of India. We have minutely discussed about different sections and amendments of the laws. Finally, you have dealt with the legalities of all these laws and role of the Supreme Court in dealing with the present crisis. Thank you once again, sir, for making you available for this webinar. Now, may I request my colleague Sri Kaustubh Das to introduce our next speaker. Thank you.
Thank you, Dr. Kisku. and hope everyone is enjoying today's evening. I'd like to introduce our second speaker, Dr. Dipankar who will now be giving us a lecture on the critical appraisal of farm laws in India, focusing on the pros and cons of the issue. Dr. a human rights activist who is a regular face on TV in national news channels as an economic and political analyst. He is the visiting professor at the University of Calcutta in the Department of Business Management and also acted as PhD supervisor. He is associated with professional bodies, namely Chamber of Commerce and Helio International France. Dr. Dey is also an author of 4 books and more than 100 research articles published in various national and international journals. He has been awarded for Best Teacher, Institution Builder, and Best Researcher from IBS Alumni Federation. There are so many things about him, but without further ado, I'd request Dr. Dey to start his lecture. Thank you. Over to you, sir. Sir, you are not audible. Please unmute yourself, sir. Please unmute yourself.
Unmute yourself.
No, sir, you are still.
Hello.
Yes, sir. Yes, sir. Yes,
Can you hear
sir.
me? Yeah, thank you. Now, thank you, Kostab. Very good evening to everyone. And I must pay my regards to Professor Chakrabarty for a very interesting and illuminating lecture, which has made us understand this law very well in a much better way. Now, adjusting the iPad is a problem. Can you see me? It's not important. Now, just before I start my topic, I just want to share an interesting update. Just I have received this message from one of my friends. This is about the press statement issued by All India Kisan Sangharsh Coordination Committee. Few minutes before they issued this statement, they have summarily rejected the committee made by the Supreme Court. And they said, I quote, Farmers Union reiterate the fact that they will not participate in any court orders committee process. Further, one of our apprehensions about such process not validated in the very constitution of the committee. It is clear that the court is being misguided by various forces, even in its constitution of a committee. These are people who are known for their support for 3 acts and have actively advocated for the same. So with this positive note, I would like to start my discussion. I would try to remind Professor Bagchi, how much time I can spend on this?
Half an hour.
Half an hour, thank you. So I'll try to remain focused on 3 basic questions. Yeah, I'll try to remain focused on 3 basic questions. Number 1, should government use taxpayers' money to subsidize farmers? This is a question which has been raised by many people, especially few politicians and economists. Second, why farm laws at this point of time? Third, what awaits India if the farm laws are implemented? Coming to the first question, whether government should use taxpayers' money to subsidize farmers. The question must be addressed. First, understanding the situation of the farmers and situation of the agricultural sector that we are into in this very time. I must, to save time, what I'm thinking, I must read out some of the notes which I have made, and I have circulated to my colleagues over there, that can be circulated later on, but I just read out to save time. Successive governments have provided farm subsidies using taxpayers' money due to various compulsions. Agriculture always faced adverse terms of trade since 1980s, and since mid-2000, the farming community has consistently faced adverse terms of trade compared to non-farmers. In 1950-51, the share of agricultural GDP was 45%, and 70% of nation's workforce was dependent on this sector. At present, the corresponding shares are 16% and 50%. I repeat, in 1950-51, agriculture contributed 45% of the GDP and 70% of the population, that is India's workforce, were engaged with agriculture. Now it is 16% of the GDP and 50% of the Indian workforce are still engaged with this. That means constant erosion of the farmers' income was an outcome of the growing inefficiency in the farm sector. In 2019, India's rank among other countries in terms of wheat and rice yields were 45 and 59 respectively. In terms of wheat, we ranked 45 among other countries who also cultivate wheat. In terms of rice, we ranked 59 compared to other countries who also cultivate rice in terms of the yield per hectare or per acre, whatever it is. The share of investment in farm sector to the total investment in the country has consistently fallen over the decades. In 1950s, the share was 18%. In 1980s, it fell to around 11%. And during 2014 and 18, it shrank further to 7.6%. So this is the share of total sectors. This is the share of agriculture's investment out of the total investment, only 7.6%, where 50% of the Indian workforce are still engaged in different ways. Every government has systematically ignored the need for investment in farm sector. All problems are tried to be resolved through ad hoc manner without proper long-term policy. For example, USA reviews and enact farm legislations in every 4 years since 1933, the New Deal year. And the European Union enacted their common agricultural policy in 1962, and every year or every alternate year, they review it. WTO shows in 2018, the government has provided $56 billion in terms of, in the recent past, the largest component, around 43% of these subsidies were provided to, quote, low-income and resource-poor farmers. According to Government of India's definition, 99.43% of farmers fall under this category, that means under low-income and resource-poor farmer category, who have less than 10 hectares of land. Now the question remains, then who gets the rest of the 57% of subsidies provided by the government? If this 99.43% poor farmers get only 43% of the subsidies which have been provided, then who gets that rest 57% of subsidies? That needs to be explored. USA and European Union provide huge subsidy to their farmers. In 2017 and 18, the US and EU government have provided 131 billion and 93 billion respectively to their farmers. If we compare the ratio of the farm subsidies to the agricultural value addition to India, US and European Union, then the figure speaks the real picture. The corresponding ratios are, in case of India, it is only 12.4%. In case of US, it is 90.8%. And in case of European Union, it is 45.3% respectively. That means out of the total value addition, Indian government provides only 12.4% of subsidy. European Union provides 45.3% of the subsidy to their farmers, and the great USA provides 90.8% subsidies to their farmers out of the total value addition that the farmers make for every product. Now the question is it too high? Is it too taxing for the country? I personally think that it is not that high. It is not at all taxing for the country. These subsidies are required because of the ad hoc policies which the government has taken for the last 70 odd years. These subsidies are required because of the increase in the cost of production of the farms. This is required because that we have followed a policy which is not suitable for Indian farmers. So that is another debate, another discussion. But at this stage, we can say very rightly and with figures that compared to many countries, India doesn't provide a substantial subsidy to their farmers. Now, the second question, why farm laws at this stage? Since last 2 decades, transnational food retailers have been targeting to make India as their global food hub. I repeat, transnational retailers have been targeting India to make their global food hub. 10 years ago, while releasing a study done by CII and Yes Bank, the then Minister, Mr. Subrata, in 2010, he was at that time the Minister for Food Processing Industries, said, quote, "The food processing sector has the potential to become the outsourcing hub for the world, and India will be feeding the world in years to come." He said this in 2010. The conference was attended by more than 50 international companies engaged in food processing and retailing. So this new initiative, which we have seen in 2020, actually this was started long back, around 2 decades before. In one of my articles in 2013, I tried to highlight the issues on allowing foreign direct investment, FDI, in India's retail trade from the perspectives of the long-term food security and systematic transfer of valuable natural resources like fertile land and water through virtual mode to developed world. The paper which I had written concluded with an observation that the fertile land and the renewable water resource of the farmers will be used like womb and blood of a surrogate mother by the transnational retailers. Unfortunately, this is very true now. The core competence of India probably lies in its food diversity, water resources in Eastern India, and knowledge of traditional farming community. Tropical fruits, organic vegetables, and various types of grains have a ready global market. India has failed to develop any global brand of industrial product. The 5 major export items of India in 2018-19 were petroleum products, which we also import and we process and then export. Around 14% of our export items were petroleum products. Pearls, precious and semi-precious stones, 7.78%. Drug formulations and biological, 4.3%. Gold and other precious metal jewelry, 3.9%. Iron and steel, 2.9%. So here we find that we don't have any product which has got the export market. We don't have any brand which has got an export market. We rely for export on gold and precious metals. We rely for export on imported crude oil, which we re-export after processing it. So it is an easy option for the Indian corporate sector and also the global corporate sector to consider food export from India as an easier option, because India is a tropical country, has huge varieties of fruits, vegetables, and so many other things, and still India has a very large pool of knowledgeable farmers who can produce varieties of food products with their traditional knowledge. And I fear these will be exploited to the largest extent to get the benefit of the international market, which these farmers probably won't gain, only the retailers will be getting out of the farmers and gain out of these total transactions. On July 1918, 2005, the Ministry of Agriculture, Government of India, and US Department of Agriculture agreed to work together to a new India-US Knowledge Initiative on Agriculture, Education, Research, Service, and Commercial Linkage. They agreed to work on a plan which included, among others, education, that is preparing graduates to harness science and technology for the pursuit of attaining and sustaining evergreen revolution, which is mentioned, quote unquote. Second, food processing and marketing. 3, biotechnology. 4, water management. To supervise this plan, a board was created consisting of eminent scientists and representatives from the government, NGOs, and private firms. The honorary members were Dr. Norman Borlaug, who was awarded with the Nobel Prize, and Dr. M.S. Swaminathan from India. Borlaug was from US. Unfortunately, he has expired. The architects of the first Green Revolution, both of them, Borlaug and Dr. Swaminathan, were the architect of the first Green Revolution of 1960s. The private sector representatives in the board were, please listen to the names, Monsanto, Archer Daniel Midland Company, and Walmart from USA. And from Indian side, the representing firms were Masani Farm and ITC Limited. To meet this objective, the government had permitted 100% foreign direct investment through automatic route in the manufacturing of food products. From year 2017-18 to the first half of 2019-20, India has received more than 2 billion FDI in the food processing sector. It may be recalled that in December 10, 1974, Henry Kissinger had submitted a confidential report titled National Security Study Memorandum 200. In short, it is also known as NSSM 200 for US security and overseas interest, also called Kissinger Report, to the US government. The Kissinger Report identified 30 key nations, India one of them, as the primary targets for population control. And the food was considered as one of the major tools through which the US wanted to achieve its objective. Kissinger commented, quote, if you control the well, you control the country. If you control the food, you control the population, unquote. Now, these are the basic triggers, I feel, which led this government to consider enacting new farm acts in the form of 3 acts that we have discussed just now, which the government has enacted and on which the farmers are protesting now. Now, my last question is, what awaits India if farm laws are implemented? We know that in September, the government of India has enacted the farm laws, and I'm not going into the details on the farm laws. What I'm just trying to highlight the consequences of this. Obviously, the first one, the Essential Commodity Act, which has been modified and annulled to a large extent. This will permit almost unrestrained hoarding and higher profit for the hoarders, as the Act clearly mentions that any action on the imposition of the stock limit should be based on the price rise and other, which Professor Chakrabarty has explained in details. I'm skipping that. The second one, the Farmers' Agreement on Price Assurance and Farm Service Act. Professor Chakrabarty has discussed in details. I'm coming to the immediate concern, of my concern and obviously others' concern on this. I think the Act provides a legal sanction for contract farming, under which farmers will produce crops as per contracts with corporate investors for a mutually agreed remuneration. The main concern is corporate investors who run global supply chains will dictate terms and look for short-term gains. They will be primarily interested in the farm output, not on the sustainable development of the farmland. We must recall that the concept of contract farm is not new in India. The indigo planters of the British East India Company started in Bengal in the century. In recent times, contract farming of sugar canes in Maharashtra's Marathwada district has made most of the land almost barren. It is reported that unrestricted use of groundwater for sugarcane farming, which is extremely water-intensive cultivation, has aggravated the groundwater crisis of the region. Though farmers have received an assured price from the sugar factories due to contractual agreement, the quality of their farmland has drastically depreciated due to bad farming practices. Experts apprehend that if the existing farming practice continues, water-stressed regions such as Marathwada could be heading towards desertification. So when someone argues that what is the harm when the farmers get assured price for their output, my question to them would be, what is the guarantee that the person who has given them the assured price will be taking care of the land, which is the real asset of the farmer? Here in this case, which I am trying to highlight, the sugarcane cultivators for years got better remunerative price compared to other farmers of that region. They were under contract farming, yes. But over the years, they had to use their own groundwater, and now the land has become barren. It has become toxic. The entire district is on the verge of desertification. Do you think that the people who have given them higher price for the sugarcane are going to compensate them for the farmland which is being desertified? Certainly not. Second issue in this case is, as I said earlier, when we promote export of food grains, we also promote export of our water. Water is very expensive nowadays. Water also gets exported in invisible way. In an embedded form along with the food grains, whatever we export. India is one of the major exporters of the beef across the globe. And beef production requires huge quantities of water. When we export basmati rice or any coarse rice, we also export huge cubic meters of, millions of cubic meters of water along with rice or wheat or whatever we export. In India this year, due to higher production of sugar canes, Government of India recently, 2 months before, have issued 3,500 crore subsidy to sugar mills. 3,500 crore subsidy to sugar mills and sugar exporters as an incentive. Why? They could not sell sugar in the domestic market due to lack of demand. Our subsidized sugar was exported to USA. Why Indian taxpayers will bear the subsidy to export sugar to USA and give this subsidy to the exporters and the mill owners who could not pay the remunerative price to the sugar cultivators? These are the questions that needs to be raised and needs to be raised in every forum. Now, Professor Chakrabarty has discussed in detail about the Farm Produce Trade and Commerce Act of 2019, the APMC. He discussed, I skipped this part. What I would just like to say that this act, that the mandis and which pertains to APMC, the impact of this act will be the immediate concern. The power and revenue of the state governments will be curtailed, which Professor Chakrabarty also mentioned, due to the marginalization of the state APMCs. And an agricultural produce market committee is a marketing board established by the state government. This all of us know by now. Until May 2020, the fast sale of the agricultural produce could occur only in the market years of mandis, which they said. Now, second concern here is this act will create a new few large private buyers who will exercise monopoly power against thousands of small and marginal farmers. This is the real concern that I have. A study suggests that agricultural output price and credit markets are highly interlinked. I repeat, agricultural output price and credit markets are highly interlinked. Weak credit markets result in the inefficient performance of agricultural markets. In the absence of proper credit facilities, small farmers will be compelled to take a loan from the affluent buyers and would sell their products at a discounted price. Farmers will become the price takers. The experience of countries where large retailers control food markets suggests rapid erosion of income of the farmers, particularly the small and marginal farmers. An Oxfam study of 2004 revealed that while exporting apples from Africa to Europe, the African farmers as a whole got only 9% of the total price of exported apple. I repeat, only 9% of the total price of an exported apple. The overseas retailers in the UK cornered 42% share, and the rest went to other stakeholders like agents, packers, transporters at all. In 1981, a similar UN study also suggested a picture of a deprivation of local producers in Southeast Asia, especially pineapple and banana producers of Philippines and Thailand. The corporate intervention in Indian farm sector began with a bang in the mid-60s in the name of Green Revolution, we know that. The program initiated by the Rockefeller Foundation USA had introduced a new cultivation process that is completely dependent on corporate sector for agricultural inputs like seeds, chemical fertilizers, pesticides, sustained water supply. The marketing of products was primarily left with the government control mechanism like minimum support price, MPS, a public distribution system, PDS, APMC, etc. Now, these three new acts of 2020 have shifted the marketing responsibility of the marketing community of agricultural commodities from the state to private corporations. Thus, corporatization of Indian agriculture has been completed. These policy changes and huge inflow of FDIs will certainly boost export of food products by transnational corporations, but it will also endanger the food security of millions of economically disadvantaged citizens of the country. Moreover, along with food grains, India will export its precious water in virtual mode as food production consumes huge quantities of fresh water, which is increasingly become scarce in every passing day. The long-term food availability to Indians will be at the stake due to systematic transfer of valuable natural resources like jal, jungle, jameen through virtual mode to the developed world. Fertile land and water resources of the farmers will be used, as I said earlier, as the womb and blood of a surrogate mother by transnational food retailers. Since it was initiated economic liberation policies 3 decades ago, India has consistently submitted in the WTO that its agricultural policies are designed to ensure food security and protect farmers from the uncertainties of market forces. India could therefore justify its imposition of high input tariffs by saying they were needed to protect its agriculture from the heavily subsidized products that were traded in international markets. However, how consistent or compatible would be the government's stand on protecting Indian farmers be with this new found aspiration of turning the country into an agricultural export hub? It is the real question. We always defended us in the WTO, saying that we had to impose higher tariff on agricultural imports because our farmers could not compete with the subsidized price of wheat and other agricultural products from USA or European Union. We have seen that US provides almost 91% of the subsidies on the value addition. European Union provides almost 45%. So we said that we provide only 12 or 13%. So at this stage, we cannot compete with you. Our farmers cannot compete with you. So we had to raise the import duty on different agricultural products. Now we are exporting agricultural products to different countries, our subsidized agricultural products to different countries. We are not talking about food security of the millions of hungry Indians. We are now saying that India has become an export hub. So if this is the logic, then how would we defend in WTO when US and European Union raise this question? Then how you can justify that import duty on agricultural products should be still very high? It means it will force us to reduce import duty on agricultural products. So India will be a good market for US food products, mainly corn, wheat, because they subsidize immensely. US cotton will be flooding Indian market, and US food, different types of US food, which are not GMO level, because US, you know that they don't they have not agreed to level the GMO foods with the GMO level. So we won't be knowing which of the foods which are that those will be imported into India are of GM products, are GM seeds. So this is the consequence which I fear will be subjected to. Now India will be importing probably lots of GM foods, cheap GM foods from US and other countries, because we'll be forced to open up our protected market. Our farmers will be forced to export products, again through the agents, again through the global retailers, to the international markets. And these products which will be exported will be all green products, like organic products, which will be produced using not by groundwater, contaminated groundwater, arsenic contaminated groundwater, but by rainwater. And it will be they will be following high standard of production, which suits the global consumers. And there will be two distinct types of consumers in the country. One elite group of consumers will be consuming those high-end organic foods, and millions of Indian consumers will be consuming all these kind of junk foods produced with GM seeds and all these kind of things, which will be imported. Now, I'll just take 2 more minutes. The Food Corporation of India, along with 500,000 odd fair price shops, probably become redundant. Eventually, FCI go down and the ration dealers network will be taken over by global retailers like Walmart's and at throwaway price, because government is not privatizing everything. So you do not know, maybe the next phase they will privatize FCI. The ration dealers will turn to procurement and sales agents of global retailers. They will procure exotic food items for export and would sell GM seeds, pesticides, low-grade imported grades, and animal feeds to millions of poor farmers. The food security of a large section of the population will be at risk. So this is my humble submission till now. If you have any questions, I'll try to address those things. Thank you, sir. Thank you, Professor Bagchi. Thank you, all the panelists, and thank you for listening. Thank you very much.
Thank you. Thank you very much, sir, for your erudite lecture. Due to the shortage of time, I'm not going to elaborate the summarization of the speech given by Dr. Day. Just I want to highlight few of them, as he has divided his lecture by focusing on 3 major questions. Those are whether the government should use taxpayers' money to subsidize farmers. Now, why these farm laws, and also stated what waits for India if the farm laws are implemented. He tried to highlight the issues on allowing foreign direct investment in Indian retail trade from the perspective of long-term food security, as well as he talked about recent Supreme Court opinions. He talked about the systematic transfer of our natural resources, especially focusing on the use and misuse of water. He talked about the decadal constant erosion of farmers' income due to the context of agricultural, in the context of agriculture and GDP, constant shrinking of investment in the farming sector, the questions of land holding, the subsidies, he compared the subsidies given by our country with the other USA and European Unions, and obviously he raised the issues regarding the easier option of considering the organic foods to export for our country. And he also highlighted the contract farming that was started during the British period in Bengal and the present context in Maharashtra and their effect, as well as he also talked about the effect of mandis, the effect of these new bills on the mandis, and as well as consumers' perspectives, whether they are the elites or the millions Indians, and whether they are consuming organic products, as well as the millions of people who are consuming the junk foods. So there are so many things that I might left, but due to time's constraint, I'm stopping myself here. So thank you, sir, for taking time out of your busy schedule. Now I'm requesting Shubhendu Maji, faculty member of the Department of Anthropology, to carry forward this session. Thank you, Shubhendu. Shubhendu, you are not audible.
Now I am audible. Yeah. Thank you, Kostov, for giving me the screen over here. It's not a floor, it's a virtual platform, so it's a screen. Thank you for sharing the screen. So now I would like to welcome Professor Sujato Bhadra. Professor Sujato Bhadra is basically our sir is basically a history teacher. He was associated with Shippu Dinobandhu institutions, undergraduate college under University of Calcutta. Now he is a guest faculty in the department of Anthropology in the course of Human Rights, postgraduate course of Human Rights. It is my pleasure to introduce you, sir. Apart from any kind of formal introduction, as we discussed earlier, without wasting any more time, I would like to welcome you here to start your speech, as we know that you are one of the most important and significant and very dynamic face in our department or in any academia, as well as in any activist platform. Thank you for being here, and please welcome, sir. The screen is yours. Thanks.
Thank you very much for inviting me to this study circle. I will emphasize not on the economic aspects of the law that has been quite dealt with by Professor Day and also Professor Manik. I will take up the issues of the movement and the responses by the government and the contentious issues involved in the movement. Number one, whether the central government has got any constitutional jurisdiction to enact essential laws relating to agriculture, which is exclusively a part of the state subject under Article 246 of Constitution of India. Government used this of 33 by saying it's a part of trade and commerce. So reinterpretation of the Constitution by the central government has raised number of issues and created tension between the federal structure of the entire nation. Surprisingly, you must be noting that in 2019 November, Finance Commission issued published a report saying that all states should be given incentive in terms of monetary, in terms of other logistic, to have a production boom in agriculture and to protect the rights of the agriculture, farmers. In 2020, in the budget statement, Finance Minister said the same thing, to give protection and incentive to farmers under state direction, under state intervention. The question of central law did not arise at that point of time. Somehow in June 2020, central government changed its previous position, few months back, previous position, and almost imposed central laws on the farmers. Why? There is no answer to that. Why government changed the stand all of a sudden? While saying that state is responsible for incentive and the central government will cooperate with the state, all of a sudden, central government took the entire initiative, imposed farmer laws on farming community, as if the patriarchal, they know they can do everything good for the farmer. Farmers do not know anything about their welfare. Reason is two, as far as I gather. One is, there is just 2 months back, USA lodged complaint against India in WTO, referring to agreement on agriculture issue and saying that minimum support price of wheat and paddy is much more, should be reduced. You will be astonished to find what they're demanding USA 2 months ago in a complaint to WTO, that at present, the MCP for rice, 1,348, for wheat, 1,386. USA saying the MCP should be for 235 and 354 rupees only, respectively. And they are referring to the clause, why they want to dismantle mandis, they want to deregulate the markets, they want to enter Indian market, to send their excessive production to Indian market, thereby destroying the life and livelihood of farmers of India. We have experiences. In 1990s, same thing happened in Philippines, same thing happened in Burdwan, where farmers, community farmers, completely destroyed, and they were in peril. The same thing going to happen. And as well as local, as everybody says, local corporate elites are entering the market, capture the market. So government intervention, government protection is required. Government is saying the APMC will exist along with open market. So you have a contact farming system now, if it is implemented at all. Contact farming means once I am in contact with the businessman, I cannot sell my produce at gate in APMC. I cannot. They will take me to the court. Simply I was in contact for 3 years, I cannot sell. If it is much more higher price if available, even in NCP. Reliance just last week had a deal in Karnataka where they had given 82 rupees more than government NCP. It appears that they are giving more, but not that. They will take commission out of that 1.5%. An entire sending of produce will be charged by Reliance on the farmers. So ultimately, they will incur losses. MPS is connected. Don't see in isolation. MPS, as farmers are saying, they are sending material to us. The MPS is connected with procurement system and timely purchase. There is a scholar, Gauranga Sahai, of Tata Institute, made a research work. The delay of purchasing by the government even will entirely destroy the entire produce. They have to feed this to the animals. They can't sell thereafter. So they require a protection. Christopher Jefflot wrote an article, brilliant article in Indian Express. Then USA and Europe, even in that advanced countries, farmers are given huge subsidies, huge cash handouts. India cannot afford to that to 120 million. Then half of the budget will be given for subsidy. That cannot be done. But if NCP is legalized, if the MSP is guaranteed, then at a standard is legalized, then private player or government mandis can break the law, cannot break the law, and they will survive. What is the demand for the reasonable price? Farmers are saying two. One, cost of the production should be covered. Two, a modest life for the farmers. Once you destroy this, in Punjab, in everywhere, keeping in the mind the agrarian crisis, keeping in the mind the debt, keeping in the mind the suicide of the farmers over the decades. In Punjab, in one village, 57 widows because of the farmer suicide. So you require a protection in our type of economy. You cannot just take the Western model and plant it on Indian soil. Now there is a government response. I must say, it's a double standard. Sorry to say. There is a RTI, right to information. There is a consultation process. Supreme Court also raised these issues. Last 2 days, Supreme Court said, what is the consultation process? Government claiming that there was a consultation process before the framing and passing of the laws. Government saying that there were lakhs and lakhs farmers were consulted on webinar said by Ravi Prasad, Law Minister. RTI says, Agriculture Department is saying, inquiry to RTI, no record is in existence. What a government petition in the Supreme Court regarding the consultation process is absolutely different logic. The last governments after government had been negotiating, had been deliberations, and also Gulati also said on the TV same thing. Supreme Court saying to forget about past government. What consultation you have done before the passing of the law? Absolutely no answer to that. Government consistently attacking the movement by stamping them out as Khalistanis, thereafter Maoist. Again, today Supreme Court, they said the entire movement had been hijacked by Khalistanis as IB reports. Police fabricate the reports, submit the reports, stamp out the movement, but the very essence of the movement is related to right to life and livelihood. I would like to point out another point, which is equally important, that what should be the unintended consequences of that. Professor Bagchi in the beginning raised the issue, is it a Haryana Punjab issue? I do contest that point. It is beyond Haryana and Punjab issues. It's a fight between democracy and corporate regulated economy. The laws, mainly for corporatization, lead to hunger, lead to malnutrition further. Already we are in the sloping in hunger index, and that will lead further to that. So I would say that entire my standpoint is like this. This struggle of the farmers is not a farmers only. Struggle not only for Punjab and Haryana. It has gone beyond this. What do we want? Community agriculture or corporate-led agriculture? The farmers are directly confronting the corporate. I am with the farmers. The process in defense of democracy, and we are reclaiming the republic. There is a very, very famous book written by Susan George, who wrote the first book, which is sensational seminal work, How the Other Half Dies. She wrote very recently another book, equally illuminating, Shadow Sovereigns, means the corporate run the government. Government is a face behind that corporate decides. And if we believe in democracy, we the people will their own fate. People have a right to have a choice what kind of agriculture they are going to have, what kind of condition they are going to accept. The law must be repealed. In a sense, if there a government is ready to 80% amendment, 90% amendment, then what is the use of having this law? If you buy a car, before you coming out of a showroom, if you find a car are faulty in any way, this way or that way, brake are not working properly, light are not working properly, if they repair the car, mechanic repaired the car, are you going to take that car? No. You are going to have a new car. If the law is faulty, if there is no consultation, after the movement government succumbed to discussion of 8th round, agreeing to the amendment, but if 80% amendment are demanded, government agreed to that, then what is the use of that law? Law should be thrown to dustbin. New discussion, new areas, federal structure should be restored, state opinion should be restored. Number of states came up in rebellion, passed the state laws, opposing the central laws. The entire tension has been created. To reduce the tension, government must give a definitive confidence building measure. There is a trust deficit between the farmers and the government, and to require trust, to revive the trust, government must first repeal the law, must agree to legalization or lawful measure. To then the farmer, only then we can discuss about agriculture crisis, reform for the good or reform for the bad. We will discuss that. Thank you.
Thank you, sir, for your, as usual, very enthusiastic and very informative, as well as
Just one more point to add. I have
Okay, sir, please.
that Bihar model has repeatedly been referred to. Bihar model has been referred to 2006. APMC has been abolished. But report after report, I can show you the report. I'm not taking time or economics, everybody knowing that. The National Council for Applied Economics Research reported increased volatility in the grain prices after 2006. which negatively affected the crop choices and decision of the farmers to adopt improved cultivation practice. It concluded that Bihar's repeal of APMC system and consequent increase in price volatility could be one of the reasons for low growth of agriculture in the state. And I have experiences in Punjab. Most of the workers from Bihar, they are now laborers in Punjab and Haryana. As a sad state of affairs, still politicians, for their own reasons, to sell the country to the corporates, telling all lies, all political hypocrisy they are doing should be stopped immediately for the good of the nation, the good of the people. And Professor Bagchi, Subhendu Maji asked me one question: why Bengal is not so much indifferent or not responsive to the movement? Because only 70 lakhs farmers family in Bengal. Only we have a small holding of 0.77 hectare, and they're very poor. Unlike Punjab, you have a Punjab Green Revolution. All we have Red Frankel's book Green Revolution, Indira Gandhi's attempt. So they are rich farmers. They have more bargaining power. They have more fertile land. So, but here, coming to corporate in Bengal and having a bargaining power with the marginalized farmer will not make any changes. Second is the government position. Kerala government, Chhattisgarh government, many government taken a position to oppose that. So government is taking care of the peasants' demand. So they are keeping mum. The government is there. So nothing will do. But from here, West Bengal, lot of peasant farmers join in that in the rally. Godi media did not report that.
Thank you, sir, for your lecture. Now I would like to brief, a very small brief or summary, you can say, for your enter points, whatever you have made now. The sir has done a beautiful initiation of his speech by saying that does the central law past the limit of structure, that is constitutional jurisdiction, and here this kind of structure, the surpassing of the structure is maybe the point of debate. Then he explained a kind of storytelling that, not a story, but it's information stating that there is a mysterious step taken by the government that from November 2018 to 19, government has a different stake, but after June 2020, government has a different stake, and three different laws they are imposed. The central law imposed 3 laws over this state, and there is different kinds of pressure they have exerted to the federal structure. Then sir explained that discussed about the life and livelihood of farmer, and he very categorically and very cautiously explained patriarchy of the opinion of the government, central government, as well as the corporatization of the entire farmer law. Then he also raised a very pertinent question on unintended consequences of law that leads to right to life and livelihood as well. Then sir very precisely discussed about MPS and MSPs regarding the support price, regarding the procurement of the particular product, and timely procurement. It's very important, timely procurement, where he tries to explain the background story of it, because if the time is not permeable, then maybe it leads to rotten product. It maybe go for the livestock rather than the food product of human population. So it leads to food and hunger as well. Then he also explained the concept of contract forming, and he beautifully explained why the Bihar model has failed, why the Bihar is a failed model as far the contract firm is concerned and other issues. He also dealt with my questions, especially of West Bengal, regarding the response to the recent farmer movement. So as a whole, as the entire discourse is concerned over here, sir intended to study or intended to say us to restore the federal structure in the state law over such kind of draconian three laws of central three laws. Thank you, sir, for being with us. I hope I very briefly mentioned all of your dimensions of your speech. Now, thank you again, sir, for your illuminating speech. And now I would like to free the screen for our moderator, Subrata Bagchi, for the next Q&A and other academic discourses. Thank you, sir.
Well, I would like to request Shumon Hajra of Bangladesh Evening College to just take left or not. I must say that at the very outset of this session, that we have asked, at least we have raised 23 questions, main 23 questions, of which at least 20 questions have been answered. I am still hopeful that by the end of this session, the other questions will also be answered. Only thing that has been left for us, anthropologists, to see how anthropologically we can see the farm laws and how the local culture is embedded. And of course, part of this issue has also been addressed, but we'll have to have a intense session on this, separate intense session on this. Or possibly we are going to organize such a session very soon on farm laws, how these farm laws can be called culturally inappropriate or maybe appropriate, who knows, and how these things are hurting the basic fabric, social cultural fabric of our country. So that's one thing. That's really one thing that I would like to discuss in the incoming days. But I would like to request Shumon Hajra to see whether any questions are there in the chat box, and then we can also take a few questions orally. Okay.
Okay, sir.
I would like to request Digonto Vishwas to
Well,
just.
Professor Bagchi, do you hear me?
Yeah, sure.
I have taken only 15 minutes, so I want to take 1 more minute.
Okay, sure. Floor is yours.
Is that government in 2014, the government in power, the party in power, in 2014 that they have said that they are going to follow or implement the Swaminathan Committee. Despite the fact that in 2015, as you know, the Santa Kumar Committee talked of abolition. I'm not referring to that. But 2014, the government, the party in power, promised to us that they are going to follow the Swaminathan Committee, and accusing the opposition not following the Swaminathan Committee report. Is a long report. But what is the government now doing? Not it's one of the demand of the farmer. Government is not complying with the promises they made in the election manifesto 2014. What is the what that economists can say? Well, I am not competent, but still I must mention that MCP announced by the government is based on the A2 plus F1 plus 50% formula instead of C2 plus 50% formula. So this government did not even comply with the C2 plus 50% formula as recommended by Swaminathan Committee. They are taking another formula and saying the Swaminathan formula being implemented.
Thank you. Very well.
Entire mistrust and trust deposit. I have reports. Our friend gone there from Sindhu border. They come back. Yes, tomorrow we have a dharna at Maulali. We are raising that issue. The entire trust deposit between the farmer and the government that has to be restored. Thank you.
Thank you. So I'd like to request Shumon to read the questions. Those are there in the chat box.
Okay. Thank you, sir. Thank you, sir. Okay, just 1 minute. First, I want to extend my sincere thanks to all the panelists as well as the moderator for their outstanding preparations. Now it's time for question and answer session. At present, the chat box is flooded with the praises and thank you message. So it is indeed a thought-provoking session as well as a learning lesson to all of us. So only one question is there, probably to Professor Dipankar. The question comes from Pronoy Aditya. Will you kindly share your views on the indemnification of farmers by the government on the risks under the farm laws in India? One question to Dipankar, sir. There are other questions are coming.
I think I tried to explain the implications of, and all other panelists also have tried, of the farm laws. If these are implemented, as I said, obviously there will be not only the farmers, the consumers at large, the Indian population, and mostly the poorer section of the Indian population will suffer and will face severe food security issues, and most probably will be subjected to consume junk foods, GM foods, and all kinds of foods imported from so-called advanced countries, which are subsidized. They have a huge production glut. And from India, we'll be exporting our best quality food, best quality fruits, probably the best quality rice, the best quality other processed foods. So I feel that the entire consumption process will be changed. And just I'm trying to add one thing which Professor Bagchi has raised, though I'm not an anthropologist by training. Some of the cultural issues, when he talked about the cultural issues, I just mentioned, if you have observed that in the last 10 to 15 years, Government of India has taken initiative to provide GI tag to hundreds of different products across the country. In a way, GI is very important to protect the local knowledge. But GI can also be appropriated by these foreign or these transnational corporations who can appropriate these GIs and promote these products as their own product, though the GI tags will be there. So there could be a possibility that these cultural aspects of India, which has got a huge variety, and if you just check the GI list, in the last 15 years, GI probably has been given to products of which 70 to 80% are food products. So my apprehensions are still there. India will be exporting our own exotic food products, our own the GI products, the best quality products, products produced with huge quantities of water, which we have still in abundance, at least in the eastern part of India. And we'll be importing all junk foods, GM foods. So in a way, this is what I personally feel that we are going to face. I don't know whether I've been able to address the question which has been raised, but this is my humble answer.
Thank you, sir. Thank you, sir. One humble request to the participants, please mention the name of speaker you would like to interact. I'm coming to the next question, comes from Shaktoki Pal. There are several horizontal accountability measures, such as formation of committees, that are invoked by the state. Nonetheless, there is a lack of vertical accountability, such as citizen insight by the central government in the ways certain legislations are introduced. Is there any panacea for this particular issue? Shattoki, can you mention the name?
Maybe any of the panelists can answer. I mean, if we can't really say that, I mean, it's a general question maybe raised.
So the question is open to all, actually.
Yeah. Would Sujato Babu care to react on this? Is Sujato Babu here? No, I think he is left. Possibly a network issue. Can Dr. De, Professor De, care to react on this?
Researcher on this particular topic. But if I remain focused on the farm laws and the farm acts that the agricultural sector, I have also mentioned in my presentation that in India, we have just followed ad hoc policies. If you see bearing the policies in 1960s when the Green Revolution was stimulated by, as I mentioned, by Rockefeller Foundation and with the involvement of some policy makers of India and some scientists and in the government. But apart from this, our entire policy was based on ad hocism. So when we have this kind of ad hocism, it is not expected that in such a situation that that what the question setter has raised, a very pertinent question though, such a situation that that what the question setter has raised, a very pertinent question though, the horizontal and vertical synthesis that he tried to mention. I don't think that no one has raised this issue, no one has addressed this issue, and no one has thought about it. So we don't have any direction, unfortunately. I don't blame this government only for this. Now, if you see the history of the Indian agricultural sector, which I've tried to just highlight, it is pathetic, simply to say pathetic. You see in terms of investment, see in terms of productivity, where we stand. In terms of productivity, we are 45th in the production of wheat. And we boast of a green revolution. In terms of productivity, we are 59th in terms of rice production. So where we stand, if we just open up this market, we simply will be flooded with imported products. Our farmers won't be able to compete with any of these countries, even with our neighbors like Thailand and all. Vietnam's productivity is much, much higher than our productivity in rice. We can't compete with them. Forget about the subsidized wheats from USA or Canada or Australia. Even we won't be able to compete with Thailand and Vietnam. So we never thought of our agriculture. It was absolutely ad hocism, it was absolutely political motives. And till now, 50% of our workforce, directly or indirectly, are engaged in agricultural activities. The entire COVID, we could sustain, we could at least get some food without any food riot till now, thanks to our agriculturists. They could produce it. They could produce sufficient amount of food, but not efficiently, because we never bothered to think about agricultural sector. As I mentioned in the very first paragraph of my lecture, the terms of trade had deteriorated in the last 70 odd years. Constantly it has deteriorated. Investment has declined. Now we are talking about all these issues. The farmers are practically on the street now. They cannot survive without the support of the government. You cannot say now the farmers, in Bengal there is a saying, gache tule boi kere nawa. The situation of farmers are like this. You have made them dependent on private players for the seeds, for the pesticides, for water, for fertilizer. And you don't have any control on the price of these inputs. Professor Bhadra was talking about the Swaminathan Committee. No, they have not. Government of India has not implemented any recommendation on the Swaminathan Committee. They're saying all lies. This is the condition of India. Unfortunate situation. Only $56 billion are spent as subsidies to 23 products on which subsidies are provided. As I said, more than 99% of the farmers are poor and resource poor farmers, and they get only 43% of the subsidies. Who gets 57% of the rest of the subsidies which are given? So these are the questions which needs to be raised.
Now, this is a big challenge to the Supreme Court also, whether they can now, under the principle of judicial review, declare all the laws as redundant. So in this context, now Supreme Court is trying to mediate between the farmers and the government by setting up a committee, so that the process can be delayed and so some amicable solution, may come out. So I believe that this is just also a kind of delaying tactics, so far the movement is concerned. Thank you.
Just to add what Sir has said, just now I have received, which I mentioned, in a press release, the Farmers Committee, that means who are agitating over there, they have rejected the Supreme Court suggestions of the 4-member committee. Farm Act, they have in past in the writings and in the meetings. It is absolutely. So they have rejected to negotiate with them, and they have said that the proposed march on 26 January will be held, and they will move to Delhi Center. Delhi City, inside the Delhi City on 26. This is the latest press release which I have just received. Thank you.
Okay, sir. Thank you, sir. One addition from Shattoki Pal. There is a renowned Bengali proverb, Babuder buddhi dekho, মগজে চাষের জমি ধ্বংস করে ফসল ফলায় কাগজে. I think there is no more questions left in the chat box.
Shumon, may I just interrupt you? Sorry. I think Professor Bhadra is trying to say something, and I think he is mute. So anybody kindly instruct Professor Bhadra to unmute, or is it possible to unmute from
most of the members? Are you listening to me?
Yes.
Yeah. Now. Yeah.
Most of them are 4 members. They have said, have announced their position, declared their position much before in favor of the farm laws. So going to them, convincing them, and to change their opinion is a remote possibility. So they are going to reject, and they said, day before yesterday, they have said it's a political issue. It's a political decision of the government to back the corporate, to bring the corporate from outside. And this farm law has a global angle. So therefore, they are rejecting the proposal. It's a good temporary suspension of the law. It's okay. It's okay. Supreme Court is Supreme Court is right to resolve the issue from judicial perspective. But you have to see the movement beyond judicial intervention. These farmers never made any petition to the Supreme Court. They did not go to the Supreme Court. Others go to the Supreme Court. Single petitioner gone to the law student gone to the Supreme Court, seeing the condition, horrible condition under distress they are living now for 49 days. 57 farmers were already died. So that's a different issue. They're saying repeal the law. And they're strict to that. And second, as I said, MSP should be legally guaranteed. No assurance from the government. It has no legal value. No anthropological value, what Dr. Bagchi has talking about. So they stick on that. We have to accept that. They did not pass any aspect of the Supreme Court. They say Honorable Supreme Court, more respected Supreme Court. Prior to that, by the declaration of the committee, they said no point of going to the committee because it's a discussion between the government and the farmers, protesting farmers. This committee is completely pro-farm laws.
Sir, Professor Chakrabarty say something.
Yeah, I want to actually thank you, Professor Bhadra. He told the right point. Farmers never went to the Supreme Court. This is a big point. All petitions, all the advocates who are advocating the farmers' cause, like including Advocate Dushman Dave, they were all absent before in the Supreme Court during the hearing. That indicates that the farmers are not at all in a mode to track the issue to the Supreme Court for decision because they are not they're having no faith, even maybe, if with due respect to the Supreme Court, I must say, on the all these committees and all these things. This is simply a delaying tactics. Thank you.
Okay, thank you, sir.
Sir, I have a question to Professor Bhadra and other panelists as well. As an anthropologist, I must ask you, sir, all of you, sir, that I do understand that there is some kind of draconian law. I do agree. At the same time, sir, there is a different pole that if we try to restore our federal structure, or we really wanted to restore our federal structure and state law, then, sir, why the state like West Bengal, Odisha, Jharkhand, Bihar, sir, please. Thank you, sir. Anybody, sir?
That's mainly related to structure of the law. As practiced in West Bengal, we have to wait because the present government in paradox now, because they are going to support this farmers movement on 27 January, going to pass a resolution. But in the state, they have one kind of farming and a different type of a farming, but they are in paradox. But nevertheless, as I have said, forest farmers in Bengal and the rich farmer in Punjab, Haryana, Uttar Pradesh, John, Rajasthan, John, some area, in nation, in Madhya Pradesh also. So their stake but
Gujarat and Punjab and Haryana, and livelihood of farmers in Bengal, Bihar, and Orissa, corporatization of farming community or farming leads to more suicide or something like this. Second point I'd like to flag is that the fragmentation of land holding in Bengal and Orissa and parts of Bihar are different, and we have much smaller land holdings, mainly in Bengal because of the huge population on farmland, and the population density you can consider that is one of the highest after Kerala. So these are some of the issues which I think needs to be flagged when we try to compare the condition of the farmers in two different regions of India. So these are something which needs to be understood, and You cannot practically do.
Condition of the farmer. I do dispute that because I have said I refer to strong recommend you read
Mhm.
Usha Patak, a recent article in Hindu
Correct.
in January that this corporate competition is also a myth because some companies will monopolize, they will fix the price, they will lower the price. And as I have referred to, local farmers to contact farming become enslaved and slowly going to be impeded. So in order to stop impediment, we have to block corporatization of agriculture, particularly in our third world type country, where mainly dependent 1 million people dependent as a small marginal, less than 1 hectare, between 1 and hectare. And here if corporate comes and dictate the terms, and suppose they import a lesser price gains, whatever food gains. Now that there is a movement in advanced country for green energy. And in green energy means the more ethanol, means more price, means more costly. Even the poorer consumer will not be able to buy that. So entire structure of the society, fabric of the society will be going to be destroyed by the corporate. So entire our democracy, in order to survive, overcome agrarian crisis, require more national reform, more other measures come up, not through corporatization. It's a wrong process, absolutely wrong process to an already a crisis-ridden, debt-ridden economy.
Exactly, sir. As an anthropologist, as we are anthropologists, we also agree with it. Absolutely, you're correct. All of you are correct in your own dimensions. As we also always favor to local to global growth, we study micro level, then we try to understand the micro level differences at the macro level. And we do believe and we do agree that each and every micro level ecological diversity, from animal world to any other plankton or other species, must be restored properly for the better biodiversity world. And we also agree that there must be a multiverse world, not universe world. But at the same time, sir, we are also trying to understand, when we are always trying to create a kind of binary that corporates as a draconian part without having any role of other issues. Means I'm telling you, sir, what are the role of state government over here? That's my question, and that's one of the part of my question. How the state government had been protecting our small scale farmer, economically much more backward farmers. I should not say backward, but economically not so rich farmers. So can you please give me some kind of light over here, how state government can hold its own power, to exert its own power to protect the farmers' right and go for a better livelihood?
Another point, Professor Maji, I'm trying to refer to, I had forgotten somehow, a middleman issue has been raised by the government.
Exactly.
When being run by the middleman. So once you open the market to the corporate, the deregulation of the market and the freedom given to the farmer to, as you said, to bargain with the corporate house and to get maximum profit out of that sale of farming produce. And this is again absolutely wrong. I have the argument of Arun Jaitley. I listened to argument of Swaraj, who were in opposition that 2012, when Congress attempted to move this one, a different matter, but move this one. they raise the same point. The again middleman will come. Not in a local middleman, but Walmart and other organization will come and become the middleman. And again the farmer, as government saying, suffering. They're again going to suffer. Middleman will come, or they have the bargaining power with the corporates. That's the whole issue, that a fixed price will be fixed by the corporate in a lower price. And the farmer will be forced to sell at the gate, and they have no other alternative. But
Thank you.
Thank you, sir.
We received one more questions on our live streaming platform. The question is posted by Shamrat Roy again. Do you think that this disaffection of farmers in approaching the apex court on public matter marks the watershed moment in the PIL activism regime on the judicial pronouncement in India?
yeah, and another Majis raising the issue, state government protecting our low-income group. Yeah, in some manner, that's a very populist government. So they have some populism, and populism has dangers also. But populism to creating mandis or to giving some cash handouts. As I've said, cash handouts is no solution. But to put some money in the bank account, either Kishak Samman Nidhi or local any Kishak Shri or whatever it is, they have taken populist measure. But the entire protection of the farmers by the government is still far away. And I don't think in a liberalized world, entire government protection is at all available, will be made available to the farmer. Because the entire liberalization means deregulation. And that is a strong viewpoint of the government or parties in power.
Thank you, sir. Diganto Bishwas posted two questions. First question is, in the matter of contract farming, the government agencies, if involved, will the issue be solved in corporatized agriculture? This is the first question. And the second question is, if all Indian Agricultural Service is introduced, can the problem be solved, particularly in respect to price fixation and contract farming? All the questions are open to all, sir.
Who is going to reply? Professor Day should reply.
I think on contract farming, my views are very clear. I do believe that contract farming is like, the experience till now is not good. So contract farming is like, a surrogate mother, contracting her own. So this is not going to help the farmers in any way, in any form that you want. So I am not very clear about it.
Dr. De, he is talking about if the government agency is involved.
So
I mean,
again,
what kind of contract farming can be?
Yeah, again, as I said, if the government agencies are involved, now you have to define the type of government. Now the government, if I say the government represents the state, the composition and the effectiveness of the state depends on how the state runs. Whether the state is a welfare state or whether the state is a state which is being run by corporates in absentia. So these needs to be very clearly understood. So state as a state just cannot be said that they are all sacrosanct. So there could be a rogue state, that could be a welfare state. So which type of state we are talking to? Now a welfare state can theoretically use contract farming for the benefit of the larger section of the population. So that is possible. But we have to first identify whether the state is a really welfare state or the state is a rogue state. So that cannot be a single answer to the question, I believe.
Well, second question actually, I mean, I didn't find any relation. I mean, if All India Agricultural Service is introduced, can the problem be solved, particularly in respect to price fixation and contract farming? I mean,
So
the ARS
this is bureaucratization. I don't
bureaucratic
think
experience. I mean, bureaucratization. I guess it won't be solved. I mean, price fixation and contract farming until and unless state intervenes.
Yeah.
Last question possibly relates to the choice of crop to cultivate and corporate interest in the role of government. There is a, I asked this question, I asked a question taken from this question. There is a narrative from government that the Punjab farmers should be actually uplifted from this paddy wheat cycle. It's very, water guzzling, and it's actually depleting the water level to an alarming level. So that's why we need such a kind of bill, such a kind of law to actually rescue them from this cycle. I would like to put this answer to Professor De.
Yeah, I just
Question to Professor.
very good question and partisan question also. I'll try to answer it. You see, for the last almost 50 odd years, Punjab and that particular sector, they have been following this intensive cultivation for the wheat, and they have been using the underground water, and for this reason, the quality of the land has become almost very bad because of this salinity and other issues due to large scale use of fertilizer, pesticide, and all. So they just now want to a way out to give Punjab farmers something else which they can produce, because the land is not anymore suitable for wheat and the other types of cultivation which they have been following for many years. Again, as I say, USA is surplus with wheat. Canada is surplus with wheat. They want to enter Indian market with wheat and corn. So if Punjab produces wheat, so it doesn't serve the purpose. So you have to diversify the Punjabi farmers from wheat cultivation to something else. This could be another reason why these types of narratives are being created. But actually, it is also a fact that the land has become very saline, and Punjab farmers need some other ways to get this out. Here, I would like to focus one more thing, which I mentioned just while I was discussing the story of the sugarcane cultivation. Sugarcane in India mostly cultivated in eastern sector and up to eastern part of UP, Bihar, UP, Bangladesh, and parts of West Bengal. These are the sugarcane cultivation areas. Gur আমাদের এটা বিখ্যাত জিনিস, তার থেকে বলা হয় গোড় নামটা এসেছিল. So these are something very traditional cultivation. Why? Because sugarcane is water intensive, and these areas they get huge rainfall every year. Now, in the last 40 years, sugarcane cultivation has shifted from eastern India to western India and parts of northern India in around country. Are located in that area. So the entire cultivation process has shifted from a natural water harvesting cultivation to an artificial water harvesting cultivation, which depends purely on underground water, into Western India. Marathwada was not at all a sugarcane producing district even 50 years before. Kanpur and these areas in the Western Uttar Pradesh, they never cultivated sugar. You just check. This sugarcane cultivation became intensive cultivation in the last 40-50 odd years when the sugar factories had come up in those areas and government started giving subsidies to the sugar factories and sugar production. So this entire production process, entire cultivation process became water intensive, and it depended on the underground water, resulting into desertification of those areas. So this needs to be understood, and this needs to be flagged. Now in Bengal and other areas, you don't find any sugarcane factory. Hardly 1 or 2 sugarcane factories are there in Bengal. But at one point of time, Bengal was one of the major sugarcane producers. Everything is shifted to the west. So probably we'll have to discuss these issues in another session. It's very interesting questions and very interesting issues. I think I would like to thank you and all the organizers again, that these issues are being discussed so seriously after a long gap maybe, thanks to the movement in Delhi by the farmers. Otherwise, we never thought of raising these issues. We never thought of raising these issues earlier. We have become so, in a way, intellectually ignorant about the farming community.
Maybe insipid.
Maybe. Sorry for uttering that strong word, but
Sorry.
we have become very indifferent. We have become indifferent over the years on the farming issues. Thank you.
Thank you, sir. Thank you, sir. There is no more questions left in the question answer session. I personally want to thank you all for such an engaging session. Okay. So, sir, may I request to hand over the screen to Pushpita for extending the vote of thanks.
Sure.
Thank you, sir. Thank you, sir.
Hello, sir. Am I audible?
Yeah.
So can I
Okay,
take
sir.
lead?
Yes, sir.
Yes.
Yeah, thank you.
Yeah, yes, sir.
Hi
Yeah.
to everybody.
Okay, thank
Thank
you.
you, sir.
So I would like to thank to all of our panelists, Professor Manik Chakrabarty, Professor Sujato Bhadra, and Professor Dipankar De for this wonderful and enlightening session, and to our chief mentor and moderator, Professor Subrata Sankar Bagchi, to moderating this session. And then I would like to thank to our mentors, Shubhendra Maji sir, Dr. Shubhamay Kisku sir, Kaustav Das sir, and Shoman Hajra sir to summarizing this session. And I would like to thank to all of our KSC members to organizing this kind of talk on this issue. And last but not the least, I would like to thank all of the participants to participate in this session and staying with us in our YouTube live. So we hope we will meet again in our next endeavor. So thank you. Good night.
Thank you. Thank you very much.
Thank you. Thank you, sir.
Thank you all. Thank you.